But welcome to our webinar today, the Inheritance Tax and Estate Planning webinar. So I was chatting to Sarah Westwood from Buckles, as you can see. We've worked together on mutual clients for many years now. I can't remember how many years. So when we were chatting, I wanted to kind of bring both levels of expertise together to bring you a webinar that so you can see a subject from two different angles. Because what we've always found is that historically the client was stuck in the middle. You know, they had a solicitor, they had an accountant, they had a financial planner, and they were getting advice from each different source. But that advice was no longer, was not joined up. And so in many situations, they were actually stuck in the middle because, inheritance tax is a perfect example where really all three of those areas of expertise are required to have a comprehensive approach. And so the client's stuck in the middle, getting advice from each of these different sources. And an efficient portfolio, we've always believed that we're far better off working on what we call a trusted team approach, where the financial planner, the solicitor, and the accountant, where needed, are all working together in tandem, because that way we can put our heads together, share expertise, and put together a strategy that really it has the client at the center of the focus, but with all of those different expertises included. And it just makes the life of the client so much easier because you're getting much more comprehensive advice. And so it was in one of those conversations with Sarah that we said, well, let's put together a webinar on this particular subject. So I'm going to pass over now. I'm going to stop sharing my screen, and I'm going to pass over to Sarah, who's going to kick things off. She'll tell you a little bit about herself, and she can start off the webinar on estate planning and inheritance tax.
Yes, thanks ever such a lot, Charlie, for that introduction. So I'm a partner at Buckles and the head of the Stamford office. Buckles deal with all legal services, but we also have a sort of wide range of fairly unusual services as well, dealing with sort of probate, contentious matters, and then also a very large international department dealing with areas of France, Spain, Italy, and Germany. Sadly, although there are 3 French lawyers in our Stamford office, and the Stamford office isn't that huge, it's not done anything at all to actually improve my French, which seems a bit sad. But nevertheless, so it's a really interesting offering actually, with having sort of that number of different countries that we advise on. So my personal area is specialising in individuals and in relation to wealth preservation and estate planning. So I cover wills, probate, powers of attorney, inheritance tax, care fee planning. And I know that when I say that, you're going to realise that I'm not exactly going to have you rolling around with laughter, but I'm really hoping that I'm going to be able to give you a few points of sort of real interest, really. So, we've got the obligatory, of course, lawyers disclaimer, so skipping over that briefly. So I'm going to be talking to you about sort of 4 specific areas, but they're all interlinked, really. So wills, care fees, trust wills, and powers of attorney. So we'll start off with wills, and I think everybody knows that wills are obviously vital to have, and you've either though got a little nagging voice in the background that says you really need to get around to making your will, or alternatively you've made your will already and then you think, great, I've done that, I've got that out of the way, I've never got to turn my mind to it again. And actually it's really, really important to both have a will and to review it often at various sort of different stages of life and life events. But we'll start off by having a look at what happens if you haven't got a will at all. It very much depends then on what the asset is. So first of all, you could have joint assets. So that might be a joint bank account with somebody, or a joint property owned as what's called joint tenants. And I'll talk a bit about that more in a while. If you've got any joint assets like that, then when one person dies, when one joint holder dies, it passes straight across to the other. So say, for example, it's a bank account held in joint names. On one person's death, it literally becomes then the sole bank account of the survivor. No more ado necessary than that. So you would just, for example, take a death certificate into the bank and they would convert it into the name of the survivor. And there's nothing that you can put in a will to change that. If it's a joint asset, it just goes straight to the survivor. If it's a sole asset, then the rules of intestacy take over at that point. And there's a very strict line of who inherits. So if you've got a spouse but you've got no children, then the spouse inherits everything. If you've got a spouse and children, the spouse only inherits the first £270,000. Everything after that is inherited as to half by the children and half by the spouse. And generally speaking, that's not what you would want to happen. And that's where the issues really come in terms of the problems there of if you haven't got a will, you haven't been able to say what you want to happen to everything that you've worked so hard for. So you're not in control. And that's where the key really lies there. So we'll have a look at what might be some of the little key points and when you might really want to change a will. So marriage is one of the first points, marriage or civil partnership. Quite often people don't realise that marriage or civil partnership completely revokes a will. And it is possible to have a specific clause in the will to say that I'm making this will in what's called contemplation of marriage and I don't want it to be revoked. But if that's not in the will, then marriage will automatically revoke it. And that can have, as you can probably imagine, catastrophic results really. Now, divorce doesn't revoke a will. But if you're divorced, then your ex-spouse is treated as if they died before you. So whilst you might not think, oh, I don't in that case need to change my will, actually it's still really important to make that change just so it's cleaner and there's no possibility for argument. Separation is one of the biggest areas because separation doesn't revoke a will. And therefore your spouse from whom you're separated will then still inherit if that's what the will says. So it's really key if anyone has separated or if your children have separated to make sure they've made a new will at that point. Having children is obviously a really key point to make a will. If you make a will appointing guardians, then that gives the guardians parental responsibility, and that's vitally important for things like schooling, for medical decisions, anything like that at all. It also enables you to say, for example, what age you want children to inherit. If you say nothing in a will, then children inherit at the age of 18. My children now are 19 and 21, and the thought of them having automatically inherited at 18 is really quite scary. So it's really important to be able to provide for two things really for children, to be able to have a later age than that. So if you say, for example, 25, it doesn't mean that they can't receive anything until that point, but it just means that they can't demand it. It's not theirs before that stage. So funds could be released to them for example, university fees, buying a house, but it's just not theirs to spend, perhaps less than sensibly. Cohabiting is probably one of the biggest areas because there is no such thing in law as a common law spouse in terms of any rights. So if you have a cohabitee and you don't have a will, they'll receive absolutely nothing under the intestacy rules. And one of the probably worst cases I think that I've ever dealt with was a gentleman who lived with his partner for 20 years, never had a will, died in very difficult circumstances, very unexpectedly as a result of an accident, and his partner was then going to receive absolutely nothing. And in order to inherit anything, in order to be able to just stay in the house, she then had to take the siblings of her deceased partner to court in order to be able to actually remain in the house. So it was a really distressing situation at the worst possible time. A change of wishes, that goes without saying that it's really important to change a will if you want to change something like, for example, a legacy or executors, but actually broader than that probably, just to be able to put down what your wishes are. So over the years, I've dealt with a few sort of cases where people's wishes just weren't carried through because they hadn't made a will. I think one of mine that probably was worthy of going on television to sort of air hunters was several years ago now, where a gentleman died and he got a sister, and the sister presumed that she would inherit everything. Now, actually, he'd had a brother that had predeceased him, and so under the intestacy rules, that brother was due to inherit. Because he'd predeceased, it was then the brother's children that were due to inherit, and the brother had a child. And the child had been, in very sad circumstances, obviously found dead in an NCP car park from drugs and alcohol. So we had to go further down that line to his child, and his child had been murdered at Kempton Races. So we had to go one stage further and then find his children, and we did find 2 children. We then had to have DNA testing, both of the children and of the paternal grandmother, to be able to prove that link. And so sure enough, these children were then to inherit. And the children, I have to say, were probably the most ungrateful people that I've ever come across, I think. And given that they had no connection to this gentleman who died, it was a really difficult situation for everybody, for the sister who thought she was going to inherit everything, then to have these 2 really ungrateful people inheriting. And if there'd just been a really simple will, that would have been absolutely fine. He could have just left everything to the sister. So it didn't need, in that case, to be a particularly complicated will. It could have been quite straightforward. Another one, because I do like stories, is one I'm dealing with at the moment, where I have a lady who died with no relatives in this country at all. All of the relatives are in Switzerland, and no will. So we're now down at something like 102/64, if that's a fraction of a fraction, in order to work out what share of the estate they're all going to receive. Because again, she had no parents, obviously no spouse, no children, no brothers and sisters. So it's gone to the children and the children of the children of aunts and uncles. And of course, you've got to go right down until you've exhausted a family line. So it's the biggest piece of paper that you can possibly imagine for this family tree, and all for the sort of want of a simple will. So it just really shows how important wills are to contemplate. And the last thing on the list, which is what I'm really going to go on and talk about, is about protecting assets, and that's where wills really come in. So we'll look at the use of trusts in wills, and there's lots of different reasons why you might want to trust in a will. Sometimes people want to leave their estate to charity, and quite often people will just say, I leave my estate divided equally between these specific 4 charities. The difficulty with that is that the Charity Commission demand that charities, quite understandably, maximise their inheritance. And so charities have a very heavy hand in the administration of an estate. They need to know which estate agent you're going to go with in relation to a house, what the house is going to be put on the market for, what offers are received. They have to then specifically be able to agree the offers. And this is not just where they're solely inheriting, but where they're inheriting together with other family members or beneficiaries. So quite often what we suggest instead is the use of a charitable trust in a will. It's got 2 benefits. It means that then the charities don't have a heavy hand in the will, because unless and until the trustees exercise their discretion in that charity's favour, they don't even know they're inheriting, let alone how much they're going to get. But also it gives you the flexibility of, with that charitable trust, leaving a letter that sits alongside it saying which charities you'd like to give anything to. It means that you can benefit local branches of charities rather than just the main head office of the charity. And it also means that you can change those wishes as often as you want to without having to change your will. So quite often as people go through life, different charities play a different part in your life, might have helped relatives, that type of thing. And so it's quite nice to be that flexible and to be able to say, actually, yes, I'd like to change it and I'd like to add that charity or remove that charity. Another very useful reason for a trust is beneficiaries who are divorcing or have disabilities, or there's a possibility of them going bankrupt, or and then they're in receipt of means tested benefits. If we use a discretionary trust in a will, then it enables those beneficiaries to be named in the will, but and again, unless and until the trustees give them anything from the trust, then it doesn't belong to them. So it means that, for example, for a beneficiary who is in receipt of means tested benefits or who has disabilities, it means that they can still claim their benefits and still claim any local authority support funding, but then have this trust fund on the side that the trustees can use to buy the beneficiary additional things, just to sort of make life a little bit easier. Again, with divorcing, the last thing that you would want is if you divide your estate, say, equally between your 2 children, and then you are a little bit worried about one child's marriage, you don't want to think that that child's share could end up with a divorce court. So the use of a discretionary trust is really very helpful, because it just means that assets can then just be ring-fenced and kept back until there's a point where the divorce is then over, and then the beneficiary can inherit their share. Inheritance tax planning, I'm not going to say anything more about inheritance tax planning. I'm going to leave that bit to Charlie, but trusts are very, very useful there as well. Second marriages, sort of blended families, trusts are very, very helpful again there. Quite often people think that what they're going to do is perhaps leave everything to each other, and then on the second person's death divide everything equally between all of the respective children. But you never quite know what's going to happen in the future, and people might remarry or change their will, and so it's just always sensible to put anything like that beyond any doubt at all, and just to have the certainty of being able to say through a trust exactly what's going to happen. And then the last element, which is the area I'm going to sort of focus on now, is in terms of care fee planning. So let's have a little look at that. Now, in order to explain the planning sort of mechanism, it's really important that I talk for just a minute about property ownership, because quite often your property is your biggest asset. And so that's really key in terms of how planning is structured. And when you own a property with another person in this country, there are two different ways in which you can own it. One is called joint tenants and one's called tenants in common. They both sound a bit like renting. Neither of them have anything to do with renting at all. It's just a really, frankly, daft legal term. If you own a property as joint tenants, and that's very much the default position for a married couple. So if you don't know how you own it, in all likelihood, you'll own it as joint tenants. And what that means is that you're both treated as if you own the whole property. So if one person dies, the survivor then automatically inherits the whole property. And again, as I mentioned right at the very beginning, it's an automatic process, nothing you can put in your will to change that. The alternative is that you own a property as what's called tenants in common. And that means you own a distinct share of a property, and you can leave it to whoever you like through your will. So I'm going to sort of talk more about those two phrases, but I just wanted to be able to go through them first, just so that you've got that sort of definition. So the way of remembering it is tenants in common means that you own a distinct share, and joint tenants means it passes automatically. So we'll look at the imaginatively titled Mr. and Mrs. A, and we'll look at simple wills and what happens when you've got a simple will. So Mr. and Mrs. A own their property as joint tenants, and they leave their estate to the survivor. And on the second person's death, they explain that everything is going to pass to the three children equally. So we've got our little house there with our money bags, and on the first person's death, passes to the survivor and then down to the three children. Quite a few disadvantages of simple wills. Because the survivor owns everything in their sole name, it means that care fees would completely potentially deplete those assets. It also means that the survivor could remarry, could make a new will, could make large lifetime gifts. The remarriage point, of course, is always a real concern, because the children of that initial marriage could then end up inheriting absolutely nothing, either by the survivor deliberately making a new will or simply inadvertently just remarrying and therefore revoking the original will. Looking specifically at care fees and why is it important to review wills to see whether they do have any protection about care fees, let's talk a little bit about the figures there. It's slightly disingenuous, I suppose, because the figures for annual cost of care are just under £34,000 there. And so you might think, well, that's not too bad, actually. But actually, when you add the cost of accommodation, of course, you can't have care in a care home without the accommodation as well, then the true annual cost is more like £78,000. And certainly in this area around here, fees are in the region of £1,200 to £1,500 a week. It depends on the location, depends on the level of care. So as you can imagine, £78,000 a year, it just doesn't take very long before assets are really eroded. So when anybody moves into a care home, the local authority make a financial assessment. And at that point, the first thing that they look at is income. So when they make their assessment, they assess your state pension in its entirety, and then your private pension, either in its entirety if you have no spouse, or as to half if there's a spouse. Generally, those two amounts don't add up to the annual payment for care. So what they then look at next is in terms of capital. And there they look at absolutely everything. So a house, unless there's a spouse living it, in which case it's disregarded, savings, investments, everything apart from disregarded assets, which are personal belongings, life policies, which include investment bonds. And that's a really important point, actually, just to cover briefly. If you have any investment bonds and you're ever considering what assets to use for just sort of day-to-day spending or any large spending that you want, think really carefully before any investment bonds are used, because they are disregarded for care fees at present. The local authority has very wide-ranging rules about intentional deprivation. That's if you give any assets away. So if you think, oh, I'm a little bit worried about care, I'm going to give my children £100,000 now, the local authority can claim it back no matter when you gave that gift. So there's no 7-year rule, as there is for inheritance tax for the local authority. They can go back whatever period they want in order to be able to look at what you've done in the past to potentially put assets outside their reach. So it's a really important point to bear in mind. Sometimes care is free. It's free if you're sectioned under section 117, or if you're eligible for NHS continuing healthcare. Really important thing to know about, very difficult to qualify for, because if you qualify for it, all care is free. And it's essentially if you have medical needs rather than care needs. But as I say, it's a difficult one to qualify for, but obviously something that we can advise on sort of separately. It's outside the realms of today, really. So looking again at our slides with a slightly different, slightly brighter house, this is what we had before, the position where Mr. and Mrs. A owned as joint tenants, and you can see when the survivor then, when the first person then dies, Mrs. A needs to go into a care home. The house is sold to pay her fees, and she will pay her fees until her capital gets reduced all the way to 14,250. At the point at 23,250, the local authority step in and start to assist, but you carry on paying, albeit with some assistance, until you get all the way down to 14,250. And that theoretically is calculated so that you've got enough left for your funeral and to cover any small debts, and then a little bit left to pass on. But as you can see, that really isn't a great deal to pass on. So quite often people think, well, do I give away my house then to avoid care home fees? Is that the best way of dealing with it? And it isn't. The main reason for that is because of intentional deprivation, and the local authority can argue intentional deprivation whether you give the house away as a gift, whether you put it into trust, or whether you transfer it to someone else. So the best option instead is through planning through wills. So quite often people say, as I mentioned before, I've done my will, I don't need to look at it again. But actually, not all wills are created equal, and so it's really important to have a look at the will and see what does it do. Is it a simple will that just leaves everything to the survivor, or does it have this type of planning in it? So we'll look now at trust wills and how they're set up and what they do. So we've got the even more imaginatively Mr. and Mrs. B. They own their property as tenants in common. Now we get a lot of people who do tend to say, I know what I need to be tenants in common, and then that's absolutely fine. I've protected myself, I've protected my assets. But on its own, it's not enough, because if you then have a will that just deals with your half share and just leaves it to the survivor, you're in no better a position, because all your will be saying is take my half share, leave it to my spouse, and you immediately just put Mrs. B right back in that same position that Mrs. A was in. She owns the whole of the house, and now if she needs to go into care, the house is going to be completely eroded by care fees. So instead, what Mr. and Mrs. B do is they leave their respective shares of the house and any other solely owned assets. So we've got a little sort of bag of money there that you can probably see, hopefully, and they leave it to each other just for their lifetime. Now, that sounds completely crazy, perhaps initially, because you wouldn't want it beyond life. So what could possibly be the difference between leaving it outright to Mrs. B and just leaving it to her for her lifetime? But the legal difference is really, really crucial, because then when Mr. B dies, his half doesn't pass outright to Mrs. B just for lifetime. Mrs. B still owns her own half of the house, And in terms of the half that's owned by the trustees of Mr. B, she can live there for her lifetime, she can move, she can downsize, whatever she wants to do. But crucially now, if Mrs. B needs to move into a care home, the half share of the property and the other assets, so the cash assets that are held in the trust, they don't belong to her, so they're ignored in the financial assessment. So we've got now a situation where we've taken the house and we've saved at least half of it from care fees. The other half of the house could potentially be valued at nothing, because how do you sell half a house? You can't go into an estate agent and say, I'd like to put my half on the market, please. My half's the tidy half. That's not actually. It just, nobody will buy half a house of where there's an unwilling seller of the other half. So it gives us a really good opportunity of trying to save the entire house. I wanted then just to say a little bit about trust, because I think trusts can look a little bit complicated, a little bit confusing, but all trusts are really is just a legal bucket. They're really just something for assets to sit in. There's no more magic really than that. What is fundamentally important is having the right trustees. So they have to be people that, as the word suggests, I suppose, that you trust and that you know completely will carry out your wishes, and that you are quite happy entrusting those assets. They won't own those assets personally, they'll own it in a professional capacity as trustee, but their identity is really important. People quite often want to have their children, that's fine. The difficulty is that you've got a potential conflict of interest there, because you've got the children as trustees and you've got the survivor perhaps as the person who's going to benefit during their lifetime. And the children might think, well, hang on a second, if I give money to the survivor, I'm not going to inherit that money at the end of the day, because they might take it and then spend it. Not suggesting that children would ever think that, but we see a jaundiced side of life, I guess. So it's just a really important thing to look at. I think what's always important is to know what the risk is and then know whether you're happy to take that risk. And what's also important is to bear in mind access to the trust fund, because obviously that's a key part that the survivor will want access to the trust fund. And so I'll explain in a minute that yes, absolutely, the survivor, with the permission of the trustee, so that is another important point, but the survivor does have access to the trust fund, because either funds can be lent to the survivor or given to the survivor, whichever is best. So looking briefly at what happens to the trust when Mrs. B dies, at that point, it's whatever Mr. B's will said. So Mr. B's will says that for her lifetime, it goes to Mrs. B, and then it goes back to his beneficiaries. They might be the same beneficiaries as Mrs. B's, but they might not be. Mrs. B's will would have been set up in exactly the same way. So had Mr. B survived, he would then have been the survivor, and he would have been able to live in her half share of the house, and then it would have gone on to her beneficiaries. So we've now got a situation where Mrs. B's will doesn't need that interim step. It just goes straight to her beneficiaries, and the beneficiaries of Mr. B's will inherit at the same point in time. So if the children are children of the same marriage, the two halves would come together to join up at the end of the day, with the children inheriting, for example, the whole house then at that point. So this next slide explains that even if the survivor changes their will or needs care, you can see that we've got the little sort of ring-fenced half share of the house showing that it would still go to those same chosen beneficiaries. So because in our example, Mr. B's will left everything to Mrs. B for her lifetime, she's protected for her lifetime, but when anything happens to her, those assets have to pass down to Mr. B's beneficiaries. So it doesn't matter whether in the interim she's needed care, whether she's made gifts, whether she's made a new will, remarried or cohabited, those beneficiaries are perfectly safe and perfectly protected. Sometimes people say, well, I have done this type of planning and that's fine, I've protected the house. And so we find quite often that the wills just relate to the property. And I think it probably dates back a few years now, where property was very definitely the biggest asset. now that people are living longer but not necessarily sort of healthier, and care homes are coming into the fore much more, you can often find that people have downsized and that their biggest asset isn't the house anymore, it's actually now cash assets. And if you've only protected the house, then you've lost the ability to protect all of those other cash assets which could be higher. So hence why the little picture had the drawing of the half house, but also of the money bag. What you want to be able to do is protect sole assets as well. So if one of the couple has an account of £100,000 in it, that £100,000 could then also pass into the trust so that it's protected, both from the possibility of care and the possibility of changing your will and leaving it elsewhere. So what we want to be able to do is protect as much as is possible, partly because we can come down from that, and we can give assets to the survivor if that's what's needed, but you can't go back the other way. So if, for example, the first person dies and all you've protected is the house, and then you suddenly say, oh, hang on a second, those wills were made when the house was worth £400,000 and we were going to protect 200,000. The house is now only worth 200, so we're only going to protect 100. Can we still protect the other bit? And the answer is no. It's a one-way street between the trust and the survivor as far as that's concerned. But if we put the liquid assets in the trust, then those liquid assets can be either, as I say, given to the survivor or can be lent to the survivor, because the trust is that flexible that we don't need to have any worry that the survivor will think that everything's completely tied up and they'll never have access to it. So that's all I'm going to say about wills. I'm going to turn now on to powers of attorney. Charlie, am I okay for time still? I did say I can talk for hours. So we'll look at powers of attorney. Excuse me a second. So there are a number of different types of power of attorney, and I'll cover the first few really quickly. So a specific power of attorney allows an attorney to do something really specifically. So perhaps, for example, you're going out of the country, you need to be able to buy or sell a house, and so you give somebody the ability just to take care of that one specific transaction. A general power of attorney allows an attorney to deal with all financial affairs, but it comes to an end if capacity is lost. So it's useful, but only in fairly limited circumstances, really. An enduring power of attorney and a lasting power of attorney both continue on, even if capacity is ever lost. So we'll look at enduring powers of attorney really briefly. You can't make them anymore, and they could only be made before 2007. But if you do still have an enduring power of attorney, then they're perfectly valid. It's sensible to check them because quite often they were made with a specific restriction in it that they could only be used if the donor lost capacity. So that's a really important thing to check. And quite often they were made so that the attorneys had to act jointly, which means that if any one attorney dies, the whole thing comes to an end. So if you do have an enduring power of attorney, still completely valid, but check it. You could only make an enduring power of attorney just for finances. You couldn't at that stage make one for health. With the enduring power of attorney, is then only ever sent to the Office of Public Guardian if capacity is lost. And that's a bit backwards with a lasting power of attorney. A lasting power of attorney has to be registered with the Office of Public Guardian before it can be used. So you register it straight away so that when you need to use it, you can use it without any sort of delays. The lasting power of attorney, as it says there, in terms of a financial power of attorney, can be used whether the donor is capable or has lost capacity. But for a health power of attorney, it's only ever used if you lose capacity. So nobody can look at the health power of attorney and think, right, I know what I'm going to do with that person today. No, not at all. You retain complete ability to make medical decisions for yourself unless and until you ever lose capacity. Both of them, however, have to be registered with the Office of Public Guardian. So let's look at financial powers of attorney. These are one of the most important documents you can ever make. It's impossible to sort of stress too much how crucial they are. What they do is they avoid ever having to make a deputyship application to the Court of Protection. So if ever capacity is lost through anything, dementia, stroke, accident, then everything is frozen. all assets are frozen, whether they're joint or whether they're sole. Now that's relatively new. It used to be the case that banks in the cases of joint accounts would allow the other joint holders still to operate it. But quite often what we're finding now is that banks are taking a really strict legal line and are saying, no, in order to have a joint account, both people still have to have capacity to agree that it's supposed to be joint. And if one hasn't anymore, then we won't let you operate that joint account. So they're freezing the whole thing. And that means that if you don't have a power of attorney, that account's frozen, you can't access it. The only way then to do it is to go to the Court of Protection and to be appointed as a deputy. Takes about a year, costs in the region of £3,000 to £4,000, and then there are ongoing fees payable each year to the Court of Protection for the court to be able to supervise the deputy, and also for a deputy insurance bond to make sure that the deputy doesn't make off with your assets effectively. So it's a very, very necessary institution, but not a path that you would ever want to go down. Instead, if you make a power of attorney while you've got the ability to make one, you appoint who you want to be able to manage bank accounts, sell property, do anything that you could do, with just the exceptions of they can't change your will and they can't make large gifts. So really, really key. I think one of the worst probably situations that I ever had was of a lady whose husband lost capacity and had to go into a care home, and she couldn't afford to stay in the property. So we had to apply for a deputyship order because there was no power of attorney. She couldn't afford to stay in the property at the beginning of the year. So by the end of the year that we finally got that deputyship order and a separate order allowing us to sell the house, it was just an awful situation for her, and she was just, completely at the end of her tether. It was awful. So a really, really important document to make. There are issues sometimes with power of attorneys that you've already got in place. Sometimes you've only appointed just a spouse, and that then means that if that spouse dies, and obviously you've then got nobody, or if one person loses capacity, then again that's a problem, because you can't then sell a property, because you can't have two people in one role effectively. So really important to check that if you have got a financial power of attorney, you've appointed more than just one person. And the other problem is in terms of discretionary management schemes. So these are schemes where there's a manager looking after funds that are invested, and I'm sure Charlie will talk more about these. So they're taking decisions for you on a day-to-day basis, and there has to be a specific instruction in the power of attorney to enable the attorney to continue those funds in that portfolio. Otherwise, those types of investments have to come to an end if that paragraph isn't in there. So it's really key, particularly for any powers of attorney that were made before about 2016, because that's when the ruling came in. So then let's look at health powers of attorney. So again, these are really, really crucial documents. There's no two ways about it. They're not the happiest and sunniest of little documents at all, I completely appreciate. They've very much taken over from a living will. In a living will, you used to say things like, I don't want to be artificially fed, I don't want to be resuscitated, I don't want to be left in a vegetative state. The difficulty with a living will is twofold. That first of all, the living will is supposed to be updated every year, and really nobody actually sort of ever gets round to doing that. Time goes too fast, doesn't it? And secondly, by the time the consultant's looking at that document, you've lost capacity, so there's nobody to check with that that's still your thinking. And possibly because of a risk of litigation, I would guess, they often overlook it. Instead, the attorneys stand in your shoes to be able to say, this is the types of treatment that my spouse, that my mother, my father wanted or didn't want. And they can then carry that through as if they were you. So it's a really, really powerful document, giving you control if ever there's a point in the future where you otherwise wouldn't have that control. It also, we find from the point of view of the attorneys, is that it means that sort of awful guilt factor of making those really difficult decisions isn't there, because they're just implementing your decisions. They're not making their own decisions. They're looking at what you wanted to do, at the guidance that you've given to the attorneys, and they're just following that. And that's got a whole different feel to that otherwise really difficult decision of what to say to the doctors at that sort of awful point of life. So it's really very, very useful, both from your own point of view, knowing that your wishes will be carried out, and then from the attorneys as well. And there was a really big case a couple of years ago where a chap in his 40s was knocked off his bike and was left in a minimally conscious state. And the doctors said he'd never have capacity again, but he could live another 10 years like this. His wife and his mother both said that that's not what he'd have wanted. And both of them wanted him just to be allowed to go. They were both in complete agreement. The doctors didn't agree, so it went to court. And a couple of days before Christmas, a couple of years ago, the court sided with the family. But the court specifically said, had he have had a power of attorney, none of that would have been necessary at all. The family would have made, or the attorneys would have been able to make that decision. So it really highlights just how crucial it is, because a lot of people think surely your spouse can make that decision for you. But unfortunately, they can't. There's no legal ability of next of kin unless the doctors decide to specifically ask you. Otherwise, it's the doctors that make what are called best interest decisions, and that's not always what somebody would want. You want to be able to say what types of treatment you want to have or don't want to have. So really, I think in a nutshell, probably to summarize everything, it's all about giving you control and about forward planning, really. So thank you very, very much for listening. Charlie, I hope I haven't sort of talked for too long. And then questions.
Well, should we save questions until the end?
Yeah, absolutely fine.
We'll save questions until the end. But that was brilliant. Thank you, Sarah. Could you unshare your screen? Fantastic.
Yep.
And just while I think about it, I've just put a link to a book in the chat for everybody. It's a book called 33 Meditations on Death. It doesn't sound the cheeriest of reads. It's actually really funny, but it is brilliant. And if you want to know why it's really important that you have a living will, I suggest, or now better than that, a lasting power of attorney for health. Read that book, because it talks about what a good death looks like and what a bad death looks like. And believe me, there is both. So I suggest you take a look at that book. It was recommended to me by a client, actually, and it was it's very, very good. Thank you, Sarah. That was brilliant. So I too am going to share my screen. And yeah, I've got the task of talking more about inheritance tax. Again, not the cheeriest of subjects you could possibly imagine, but actually, really, are we talking about inheritance tax? My instinct is that people don't mind about inheritance tax. They don't really care about it. What they're more interested in is about leaving a legacy, leaving the greatest legacy possible. And really, actually, that's what people's priorities are. So perhaps at the moment you're thinking, well, you know, is my hard work over my life going to be eroded by the taxman? You know, they say that the light at the end of the tunnel is the taxman holding a torch. So you don't want all of that hard work that you've put in during your lifetime to be swallowed up by the taxman. And in fact, the taxman to become your single largest beneficiary, which can be the case. And perhaps, as Sarah's already touched on, you're also worried about your estate being eroded by care fees, because we've seen the frightening costs that those are, and how quickly they can erode an estate. And perhaps, again, something that Sarah touched on, you're worried about the fact that, you know, if you pass money down to the children to minimize inheritance tax, they then marry the son or daughter-in-law from hell, get divorced, and that money leaves the family during your lifetime. And perhaps also you're worried about the fact that, yeah, it's all very well planning for inheritance tax, but how much money do you need for your lifetime? You know, that's the biggest thing that stops people planning for inheritance tax, is not being able to understand how much money they need to live their life. So I want you just to imagine briefly a time in the future where you know that you've created this amazing legacy for the people that you care most about, but you've done it at the same time as knowing that you've got all the money that you need to be financially secure in your future, and knowing that that legacy is actually going to continue to grow. So that's what I want to talk to you a bit about this morning or this afternoon. For those of you that don't know me, my name's Charlie Redding. I run a chartered financial planning business called Efficient Portfolio, predominantly based in Rutland, but we have offices elsewhere as well. We're known as, or we're now one of the UK's top financial planning practices. You don't need to take my word for that. That's what the Sunday Telegraph, Sunday Times have both said. And we also won the top Midlands financial planning business by our top industry magazine this year. I myself am a chartered financial planner as well. And I'm also the author of 3 books, Entrepreneurial Happiness, which was published last year, The Dream Retirement, published back in 2015, and Smart Money, published somewhere in between, can't remember exactly when. So I want to start off by a story that a client told me, and his words were, when I was the first meeting, he's a lovely gentleman, he's sadly no longer with us, but in that first meeting, he said to me, you know, Charlie, life is arse about face. His words, not mine, I apologize for the language. He said, life is arse about face. He said, you know, years ago, I had a wife, I had children, and I had all these amazing things that we wanted to do together, but I didn't have the time and I didn't have the money to do them. He said, now, you know, I'm old, my wife has sadly passed away, my children live actually in his situation abroad, and yet I've got all the money, I've got more money and more time than I know what to do with. So he said, I want to create a legacy. I want to give with a warm hand. And I think that's a lovely term. You know, giving with a warm hand allows you to see the legacy that you're creating. So I'm going to be talking about inheritance tax, but I want really you to be thinking about creating a legacy. Because, well, what is a legacy? Well, and what is financial planning? Well, really, financial planning is about understanding the resources you've got available to you today. It's about understanding what's important to you in the future and who's important to you in the future. And it's about building a plan that you can implement along those lines and understanding the timeframes and the risk. And that's what we do at Efficient Portfolio. And, you know, and on my journey in the last sort of 20 plus years of being in the financial services industry, I really I've worked out that if you want to create the best legacy possible, there's really 6 steps that you need to master. So the first thing you need to do, like with any big project, really, you need to prepare. You know, you're either preparing or repairing. And if you don't prepare in this situation, then all the sorts of stories that you've just heard from Sarah will happen. What you then need to do, if you want to create the best legacy possible, is you need to create a plan. You need to look forward and create a clear plan as to what you want to happen. You also need to make sure that all that money that you've worked hard to put aside, whether it be in your property, whether it be in your pension, whether it be in your ISAs, that money needs to continue to grow during your lifetime, and not just putting it in the bank. It needs to grow more than inflation. If it's growing less than inflation, you're losing money. That money is being eroded. So you need to generate a profit over and above inflation. Now, of course, you also need an income for your lifetime. That's what we often call a pension. So you need to create a dynamic income that can deliver the life that you want, so that you can, you know, tick off the bucket list as you've promised yourself. So that's kind of the next step. The 5th step on creating the best legacy possible is that things change. You know, Sarah's already highlighted several legislation changes over the years and things that have changed. So it's all very well putting the best plan in place today, but you've got to ensure that plan continues to progress with you, because if you don't, it will gradually stagnate and become less and less effective. And then finally, as I touched on right at the start of this, there's the personal aspects of creating the best legacy possible. And so this afternoon, I just want to kind of touch on a few different aspects from a series of systems that we've created to solve each of these problems. So we have what we call the Don't Wait Protection Plan to ensure that you are preparing, not repairing. In order to create the best plan to see into that financial future, we've created the Safe Retirement Roadmap. In order to get the best returns possible for a level of risk that you're comfortable with, we created the Radical Investment Approach. We created the Dream Income Strategy to help you make sure you've got sufficient income for your lifetime and to be able to do the bucket list. The Progressive Review Program is how we help our clients ensure that their financial planning evolves with them. And then finally, there's the Life Legacy Gift, which is all about that personal side of creating a legacy. So I'm going to touch on a few elements within this this afternoon. And the first element is taken from the Don't Wait Protection Plan. And that's because I really want to dive into inheritance tax. But to be able to do that, I've got to be able to, you've got to understand how inheritance tax works on a pretty basic level. So inheritance tax is taxed at 40%, but it's taxed on 40% over an allowance that you get called the nil rate band. Currently 325,000 per person. It's been that for forever. I think it's since about 2008. I think is when it was changed to that. And so everything above 325,000 per person or 650,000 per couple is taxed at 40%, which is why if you've got more than one child, you can find that your single largest benefactor is the inland revenue. Now, there is an extra allowance over and above that called the residential nil rate band. This was brought in by the coalition government when they promised everybody £1 million inheritance tax allowance, and then they kind of fudged the system and made it quite complicated so that only some people would be able to claim it. But it does mean that potentially for a couple, you can get up to £1 million allowance. For larger estates, that falls away. So if your estate is worth over £3 million, you won't benefit from that at all. And it also is linked to property. So it is quite a complicated and horrible piece of legislation. In fact, I remember going to a webinar when it was introduced by Buckles, actually, and them telling us how horrible a piece of legislation it is. I'm amazed it still exists, but in its current format. But
it hasn't got any better.
So there are a number of allowances for inheritance tax. You get an annual allowance, which means you can give £3,000 to somebody without any inheritance tax implications. And if you didn't do that last year, you can actually do that. You can make up for last year's allowance. You get a small gift allowance, so you can give as many different people £250 as you want without any inheritance tax implications. And there are also certain situations, like, for example, marriage, where you can give slightly larger gifts depending on your relationship to them. And there are some exemptions as well. So your spouse, there is a spousal exemption. So if you're giving money to your spouse, there's no inheritance tax to pay. And also if you give money to charities like the charitable trust that Sarah talked about earlier, then that will be exempt from inheritance tax. There is something that people tend not to know much about, and that's called gifts out of excess income. So I'll come on to giving capital away in just a second, but what people don't tend to realize is that you can give money out of income as long as it's regular, as long as it's genuinely out of income, not capital, and as long as it's not making an impact on your standard of living, then that money can leave your estate to whoever you want to give that excess income to, and it leaves your estate immediately. So that's quite a useful planning tool that we'll use with our clients. The thing that people tend to be more aware of is what's called potentially exempt transfers. Now, this is where you give capital away, and as long as you live for 7 years, that will be free from inheritance tax. So if you die within 7 years, there's a bit of a misconception here. People think that automatically graduates down over that 7 years. Actually, only gifts over and above the nil rate band, so only gifts over and above 325,000 taper down. Otherwise, that whole gift is essentially sat there for 7 years. So potentially exempt transfers are why former Chancellor Roy Jenkins said that inheritance tax is a voluntary tax paid by those people who distrust their family more than they dislike the inland revenue. Because in theory, you can just give away all of your money. It's really simple. It's free to do. It's cheap. It's just easy. The problem is, of course, that actually you've given up control of that money. You don't know how much you need in the future, and therefore people tend to wait until it's too late to do potentially exempt transfers. So there's that timing issue. And of course, bit to the children, they get married and divorced, and guess what? The money's leaving the family. So actually, potentially exempt transfers are really useful tools, but there's lots of drawbacks, which means they don't tend to get used so much. So when it comes to inheritance tax planning, I often describe it as being very similar to cake. A couple of reasons why. First is that you can't have your cake and eat it. So there's a rule called a gift with reservation, which basically means you can't give something away and still benefit from it. That applies to your house. You can't give that away and still benefit and still live in it unless you pay a commercial rent to your children, which is not very palatable. And equally, you can't give away the painting on your wall and then still leave it hanging on your wall because you've reserved the benefit. So with all types of inheritance tax planning, you can't have your cake and eat it, although you can start to get some kind of blurred, sort of murky water in between. The other reason it's like inheritance tax planning is like cake is that the best cakes involve layers. There's not usually one ingredient, one flavor that makes the best cake. Multiple layers will actually deliver far better planning when it comes to inheritance tax. So this afternoon, I just want to give you an insight into just a few different types of planning that you can use, some of the tools in our armory to help mitigate inheritance tax and keep more of that hard-earned money going to your loved ones as opposed to Rishi Sunak or the Chancellor at the time. Now, one really straightforward way of doing it is very similar along the lines of what Sarah was talking about earlier, which is what we call the protective gifting trust. It's essentially just giving money in, putting money into a trust. So let's say you've got £100,000 that you know that you'll never need, but you'd like to retain some control over it. You can gift that money into a trust. As long as you live for 7 years, that money's outside of your estate. You wouldn't want to be doing more than 325,000 on this, but that money can be immediately loaned out to the beneficiaries. So it's a nice way of keep retaining some control, but getting that 7-year clock ticking. But that involves giving up entirely the access to that £100,000 example in the example. Slightly different version of that is what's called a gift and loan trust. So here you might say, well, look, I've got £100,000. I need that £100,000, but I'm happy to give up the future growth. So what you can do is you say, well, from that £100,000, I want to be able to retain income and I want to be able to retain capital. But any growth on that £100,000, I want outside of the estate. So a gift and loan trust doesn't save any tax immediately, but it stops the situation getting any worse. It's only useful in a few certain situations, but it's another tool in the armory. A more powerful type of planning is what gets called a discounted gift trust. Now, this is really useful where you want to retain an income, but you're happy to give up access to the capital. So again, taking that £100,000 example, you might say, well, I'm going to put £100,000 into the discounted gift trust. I want to retain an income from that, which is typically 5% of what you've put in. So you get your £5,000 a year back, but immediately some money, and let's call it half, but it's dependent on your age and health at the time, immediately some of that money will leave your estate for inheritance tax purposes. The remainder, known as the discount, will leave, so that's the discount. The remainder is a potentially exempt transfer and will leave after 7 years. So it's fantastic if you need an income, but you know you're not going to need access to the capital. The problem we have with discounted gift trusts is that sometimes people have already got all the income they need, and therefore what we might use is a trust that gives us the option of an income, but not having to have it if we don't need it. And that's where a flexible reversionary trust comes in. Really similar to a discounted gift trust, except this time each year you get the option to take 10% back if you need it, but if you don't, you roll that 10% on to a future year. So each year you can say, well, look, I've put £100,000 in. Do I need £10,000 back? No, I don't. So I will roll it forward to a future year. So maybe, for example, in year 5, you might have rolled all first 5 years into year 5. So in year 5, you could have the option of taking 50% of your capital back if you wanted it. But if you don't want it, you leave it in the trust. And all of that money will leave your estate over a 7-year period because it's all a potentially exempt transfer. But during that time, you could also make loans and appointments out to the beneficiaries. So with all of those trusts, we've essentially given up some form of access, haven't we? We can't have our cake and eat it in its entirety. We've basically, some are giving up all the capital, some are giving up some of the capital, some are retaining income. But that's the beauty of trust planning, is that we can start to get that money out of the estate. Now, a different way of doing inheritance tax planning is using a relief known as business property relief. Now, business property relief is the relief that means as the owner of an efficient portfolio, I can pass that business on to my children without paying inheritance tax. Same applies to farming. They have an agricultural property relief, which allows them to pass the farm from generation to generation. But I'm not suggesting that you necessarily go and set up your own business in retirement just to try and mitigate inheritance tax. Clearly, that wouldn't be very practical. So companies that aren't listed on the main stock exchange in the UK, so the FTSE 350, also qualify for business property relief. So that means that companies listed on the A market, like Majestic or now Naked Wines, Boohoo, Fever Tree Tonic, do qualify for business property relief. Now, the nice thing about business property relief is that you only have to have held the asset for 2 years for it to be free of inheritance tax. And not only that, it's still your money. So if you want to sell it in the future and spend it or draw an income from it, you can. So AIM listed portfolios are very good from an inheritance tax planning point of view. The The problem is they're extremely high risk from an investment point of view, and there's not much point in doing something to try and save 40% tax, but losing 50% on the investment because you've picked some really high risk investments. So we find that AIM portfolios aren't actually that practical for most of our clients that are focused on inheritance tax. And as a result, we tend to spend more time looking at business property relief portfolios that are designed on minimizing tax, but retaining that business property relief because of the powerful tax savings. A couple of examples that fall into this category are renewable energy. So there's quite a few that are based on the renewable energy world, and the returns from those are typically government backed. So things like the feed-in tariff for solar, the renewable heat incentive for ground source heat pumps. So those sorts of investments can be kind of essentially created to try and get you business property relief, but also keep the risk as minimal as possible. Another example is a storage company. Most property-based businesses are excluded from this type of planning, but a storage company is a classic example of a company where really probably 80% of the underlying value of the business is the property that it sits in. If the storage company was to go bust, the property is still there and still retaining a significant amount of value. So these types of investments are quite different to, within the trusts, you could put your traditional investment portfolio in there. Whereas when I say you can't have your cake and eat it with business property relief, that's because you're restricted on what investments you can use to invest in. And so therefore, you wouldn't want all of your eggs in this basket, and it's not right for certain types of investors. But it's another great string to the bow. It's another tool in the armory. It's another layer to that cake to say, well, okay, we'll want some money that we can access if we need it. Sometimes people are, elderly and they're not sure that they've got 7 years to complete the inheritance tax planning. So therefore 2 years becomes more attractive as well. So there's lots of reasons why this is another useful tool in the armory. There are some more aggressive tax planning strategies out there. We're generally not in favor of them. The revenue is just, comes down on aggressive tax planning so hard. You don't know, you only have to have read the paper whether it was Gary Barlow or Jimmy Carr. It's not the environment to be doing aggressive tax planning. In some more complicated situations, there are kind of not aggressive, but sort of halfway houses that are a bit more complicated than I can go into today. But there are some alternative strategies out there, but I would discourage you from going towards the aggressive end of the market because I just don't think it's the environment to be doing it. Now, one thing I haven't talked about is property and putting property into trusts. Now, putting property into trusts on your death, as Sarah was talking about earlier, makes a huge amount of sense for care fee planning, for inheritance tax, for protecting the assets going down the bloodline. But putting property into trusts during your lifetime to mitigate inheritance tax is actually a bit of a messy game. Properties get taxed very highly in trusts, and also you can often pay tax getting the property into trust in the first place. So if you own multiple properties, it's actually quite difficult to do some of the inheritance tax planning that we would look at. And indeed, if a lot of your wealth is tied up in your primary residence, as it is for most people, again, that's quite difficult to do inheritance tax planning with. It's not impossible, but it is difficult. And so therefore, what I always kind of come back to is, and I describe as the last chance saloon, is something that is worth considering. And that is essentially ensuring that liability. I said at the start of this, ultimately, we're not actually bothered about inheritance tax. We want to create the greatest legacy possible for our children. And so sometimes instead of disturbing all of the assets and paying extra tax during your lifetime and making it really complicated, what you can do is you can mitigate that inheritance tax and just say, look, as and when something happens to us, we've put a plan in place to make sure there's a lump of money that's sitting in trust outside of our estate to just pay the inheritance tax. Sometimes that is the easiest route. So I want to dive now very briefly into what I call the Safe Retirement Roadmap and one particular element of it. And that's because I've alluded to this a few times, but the problem with inheritance tax planning is actually knowing how much you need for your own financial future. And without a crystal ball, it's very difficult to know that. You know, I used to have a crystal ball, but I broke it a couple of weeks ago. I didn't see that coming, stupidly, but anyway. So what I often talk about, kind of seeing into your financial future and almost having like a financial sat nav to guide you on your financial journey. And that's why we use, for all of our clients, a tool called lifetime cash flow forecasting. Because if you don't know how much money you need in the future, it's very difficult to know how much you can give away to be able to mitigate inheritance tax. So I just want to briefly explain what a lifetime cash flow forecast is and how it works. So this chart here is showing income versus expenditure for somebody right the way through to their age 100. Now, we always model everybody to age 100. You may think that seems too long. You may not think that you're going to get there. But if you've planned to run out of money at 90 and you do get to 100, like many people will and do, you've got too much life at the end of your money. And that's a slightly awkward situation to be in. So what we're seeing here is this black line that runs along the top of the blue blocks is the required expenditure for each year. The blue blocks are the amount of income that's available for this person. And by the way, this is a genuine client of mine. He's actually world famous at what he does. And the red is highlighting that he has insufficient income to meet his expenditure. So if this guy lives to 100, then he's going to run out of income before he gets there. The second key chart is actually probably tells a better story for this particular client. And this is showing what's going on in the background for each of those years. How much is his cash, his investments, and his pensions worth for each of those years? Yellow is cash, orange is investments, brown is pensions. So you can see this person's come to me in a very organized fashion already. He's got over £500,000 sat in his bank accounts. He's got investments. He's got a good chunk in pensions. And if he keeps going as he's currently going, he will have spent everything before he gets to age 100, and there will be nothing there to inherit. So the lifetime cash flow forecast, and as I say, this is a very successful person. If you knew who it was, you'd be very surprised to hear that he's on track to run out. So one of the things that lifetime cash flow forecasting allows you to do is then model different scenarios. So we didn't ask him to save any more money, spend any less money. All we did was revise his strategy, and we can look at multiple different strategies to optimize this. But we could quickly eliminate that red to make sure he'd got sufficient income to live through to age 100. But what tells a better story again is this second chart, because what we were able to do by revising that strategy is not only were we able to mean that actually instead of his children inheriting nothing at age 100, we can provide them with £1.4 million in today's money. So that's eliminating the effect of inflation at age 100 by him not spending any less money. Not only could we do that, we can optimize the strategy to make sure that all or most of that is free of inheritance tax. So lifetime cash flow forecasting is an incredibly powerful tool to see into the future, check you're on track for what you need, and then building a plan that can create the future that your children need. And at the golf club, I quite often hear people talking about ski holidays. Some of the older members talk about ski holidays. Turns out that skiing doesn't actually have to involve snow, because ski holidays stands for spend kids inheritance. So if you want to spend the kids inheritance, you can absolutely model that too. So we'll quite often model people's bucket list income and make sure they can afford to do all of the bucket list, but even if they still live to 100, they can still have enough. So that's kind of a brief synopsis of what's going on in the Safe Retirement Roadmap. When it comes to the Radical Investment approach, I said it was all about generating profit over and above inflation. I don't have time to cover this afternoon, but I just want to briefly show you what, if you put your money in the bank, that's what's happening to your money. It's being eroded by inflation. We all know it's happening on other assets. You know, a chomp bar was 10p when I was at school. I think it's now about 50p. But not only that, the blasted chomp bar is smaller than it was when I was at school. You know, I think we get one less Jaffa cake per packet than we used to. So this is what's happening to our assets if we don't get growth over and above inflation. And so having the proper investment approach, having a properly diversified approach to give you the best returns possible for a level of risk that you're comfortable with is just absolutely vital. And so that's what we do, helping our clients kind of generate that growth and actually making sure they get have that legacy continue to build. And it really does work exceptionally well, even when we have the year like we had last year with the greatest stock market crash in living memory. So it really is extremely effective at creating that. Couple of last points that I'm going to take from the Dream Income strategy. Pensions are an incredibly valuable inheritance tax planning tool. So we would always encourage clients to spend those last. They are brilliant if you die before 75. Even if you die beyond 75, they're still very efficient from an inheritance tax point of view. So protect those pensions in exchange for spending the ISAs. You know, ISAs are a bit of a trap. We get told to kind of save into ISAs, rightfully so, during our lifetime, and then we're reluctant to spend them in retirement, and then the tax man comes along and takes 40% of them when you die. So that income strategy is also really important around how you mitigate inheritance tax. And now I just finally want to jump into something which I call the life legacy gift. I'm going to skip through this really quickly because I'm running out of time. But I often talk a lot about leaving a legacy, not just a will. And I kind of talk about it in this life legacy gift piece, which actually is the title of my next book, which will be published in the next couple of months. So I did think about calling it Death, a User's Guide, but I decided that wouldn't be very appealing. So the life legacy gift is probably a better way of describing it. But a legacy is about so much more than just the money. And that's why I wanted to give people a guide as to how they could create the best legacy possible, not just from a financial perspective. I just want to give you a couple of examples as to what that's going to be about. And so firstly, in my book, The Dream Retirement, I talked about the grandparent interviews. Wouldn't it be amazing if you had a video of your great grandparents telling you what life was like when they were growing up and what virtues their parents bestowed on them, and kind of how they got into the business that they did, and all of those sorts of things? Wouldn't that be really good? And it'd be amazing if I'd got that video of my great grandparents that I could show you today to show you how good it was. But of course, nowadays we have all the technology we need to do that sat in our pocket. We can create those videos. So with interview questions that are all in the Dream Retirement book, we interviewed my parents, my in-laws as well. You can actually see those two as examples on our website. But it's just such a lovely thing because we can pass that on from generation to generation. So it's very easy for that to become too late. Don't let it become too late. Do it now while you can. Another example of a legacy is that my grandfather, who died when I was 12, entrepreneurial guy, he set up a farming on his own, a farm just near Corby, despite his family's advice against it, because it was just before World War II, and they were worried about bombing because of Corby Steelworks, and actually that came to fruition. Had troops all over their farm, but he was an entrepreneurial guy. And so by his entrepreneurial nature, that's been passed down through the generations to me running my own business. But he was also very kind in the sense that he left, as part of his will, he left me a relatively small amount of money, but that money I used to go traveling when I realized that actually farming wasn't for me. And if he hadn't left me that money and I hadn't gone traveling, I probably would have never set up Efficient Portfolio. So he gave me a legacy that, it would have been very easy for him just to leave everything to his children at the time. My grandmother, on the other hand, left a very different legacy. She wrote down all of the stories around the farm when they were growing up. And I've got this wonderful booklet of kind of, the troops going up, the tanks going up and down the farm drive, and the shock on her face when a busload of Indian soldiers arrived in the village, and kind of all of these wonderful things that would be totally lost if she hadn't taken the time to write this stuff down. Now, you could do that in a book, you can do that in just a, kind of whatever format that you want to, but all of these legacies are amazingly powerful, and you can create that legacy. So just very quickly, if you want our help at Efficient Portfolio, we have our own unique process that we take clients through. I'm not going to go through all of that process with you now, but the start of that process is what we call the financial breakthrough call. So if, having heard about what we do and also what Sarah does, you think we might be able to help, then we'd be really happy to have that conversation. That's a conversation with one of the chartered financial planners at Efficient Portfolio, or if you can contact Sarah direct for her stuff, but we're really happy to have that conversation. Talk you through, kind of make sure we A, can help you, and B, find the best person within the business to help you. We have a team of client relationship managers as well at Efficient Portfolio, because it is very much a team-based approach. So if you want to take us up on that offer of a free personal finance call, you're very welcome to. I'll leave you with one final thought before we take questions, and that is, at Efficient Portfolio, we say that we're all about creating a better future through inspirational financial planning. So if we can help you create a better legacy for the people that you care most about through financial planning, we'd absolutely love to do that. So thank you very much for dialing in. If you want to ask any questions, that's brilliant. I can see there's a few. Actually, I forgot to mention at the start, there's a chat box and there's a question and answer. I see we've got a question in the some questions in the question and answer, but we've also got some in the chat. So I'll read out the ones in the chat. But Carrier has asked a question to you, Sarah. That is, do you recommend will trust to be created during lifetime with £10, but it becomes operational on death with a settlement? And if so, why?
Unfortunately.
Oh, you're on mute, Sarah, I think.
Oh, I think I should be unmuted.
You're now, we can hear you now. Yes.
Oh, okay, must just be a little lag. I thought I wasn't going to get any more technical hitches there. So it used to be a very, very good tax planning device, because you could set up these pilot trusts with £10 in it, and then in the will you could just divide it equally between the 4 pilot trusts, and each pilot trust would have its own individual nil rate band. Unfortunately, that all got changed perhaps about 6-ish years ago, I think. Charlie, is that about your recollection?
Sounds about right.
Yeah, I think it's about right. And unfortunately now it doesn't work, because everything that goes into those trusts on the same day are all treated as related settlements. So sadly, there's very little point in actually doing that now. You could instead just in the will just leave it to that particular trust, and it would have the same effect. There are other reasons that you do set up trusts during your lifetime with £10 in it. For example, for pension death benefits, that's very, very useful, because otherwise if the death benefits from your pension just pass straight to a spouse, they're not taxed obviously at the point they pass to a spouse. That's all spouse exempt. But then when the spouse dies, then at that point they'd be taxed. And if instead a bypass trust or a discretionary trust was set up with that £10 in it, then that can actually take the death benefits, the spouse as a beneficiary along with the children, and then it's not taxed on the spouse's death.
Is there, just to follow on from that, is there a benefit to having what we're talking about here is pilot trusts as opposed to trusts that are essentially created on the day you die, aren't we?
Yeah.
Obviously, if the trust is created on the day you die, it's subject to the legislation at that time, isn't it? Is there a benefit to setting them up today so you know what the legislation is, or does that not really?
Not really, because historically, again, the legislation would just track it, really. So a bit of a shame, really. You don't really get any sort of retrospective benefit and protection for lifetime. What you tend then to get is some sort of transitional reliefs, if you like, where they say they're going to introduce something and they give you a couple of years to change your trust in order that it complies, but not lifelong protection like that. The other difficulty with a pilot trust is it would then have a 10-year anniversary whenever you set up the initial thing, rather than say on the date of your death 10 years from then.
Okay, yeah, brilliant, thank you. A question in the chat box is around, you mentioned for care fees that 50% of the pension income for a couple would be kind of taken into the means test for care fees, but how does that work for pensions that are in drawdown now? Because obviously this is sort of much more prevalent now that people are tending not to buy annuities. Is that pension just seen as another asset that's all got to be spent, or is it, how does
Yeah,
it?
so if you're not drawing it down, could you just leave it there? Sadly, they've thought of that one too, and they do make a calculation based on what they feel that you would take reasonably. I can send the calculation sort of later, but yes, you can't just protect it like that. We would say exactly the same as you, Charlie, spend your pension last, but unfortunately you can't just say, well, I'm sorry, but I'm not drawing down from it for care fees.
But it is at least a calculation that's aimed to sort of see out your lifetime, as opposed to them saying, well, you've actually got to just spend all of this over the next 2 or 3 years.
Absolutely.
And when it's run out, will help.
Absolutely. Yeah.
Okay. And actually, and there's another question that I'd got sort of related to that. You mentioned the deliberate deprivation of assets for care fee planning, and saying, well, you can't just kind of give stuff away to mitigate it. And you also mentioned the investment bonds as a good way of kind of protecting. Is there really any guidance for people on how soon, when they should be investing into an investment bond that would still mean that it wouldn't then be seen as a deliberate deprivation of assets if they went to a care home in the future?
Yeah, so they don't regard the investment bonds as deliberate deprivation at all, because it is still an asset and it is still in your name. So despite the fact that it's disregarded, it's not on that deprivation list. I think what is important, though, is that an investment bond then will be part of the whole financial planning process. So I don't think you could say that there was no other reason why you decided to invest in that investment bond. But generally, with your financial planning sort of meetings and the very, very careful reports, your reasoning then for investing in that particular investment bond will be so strong that it would have nothing then to do with care fee planning, and therefore it would be successful. They were going to try and change the loophole, perhaps, oh gosh, time goes too quickly, doesn't it, maybe 4 or 5 years ago, but there was a lot of talk about it, and then it all went away and it's never come back since. So at the moment, investment bonds are still absolutely protected.
That's interesting, actually, because I'd always assumed that you would have to be relatively careful with that deliberate deprivation, because I remember there being talk about that being a problem.
Yeah.
But that's actually, yeah, that's even better from a
no, it's good. It is really difficult because there's no 7-year sort of clock with it. The local authority, as I say, can look back no matter how far back in time it is, and that's really difficult because they've got a very unfair, I would say, really sort of mantra that if you're over 65, then you ought to have care in your reasonable contemplation, so shouldn't give away anything because you ought to be thinking about your care. Whereas at 65, no, you're wanting to, as you say, help your children, help your grandchildren, all of those sorts of things. So I think that it would be very difficult for them to argue that any kind of substantial gift is trying to thwart them. They do have to link the wish to give something away with the deliberate intention to deprive yourself of funds for them. But you've got to have a really good reason for doing it, like an investment bond, or for giving it away that you can show is nothing to do with care.
Brilliant, thank you. If anybody's got any other questions, you can put them in the question and answer bit, or you can put them in the chat box, or you can just raise your hand, or I don't know, actually, I'm not sure you can raise your hand on this format, but you can put a message in and we can unmute you and you can ask the question in person if you prefer. Anybody got any other questions? Well, if we haven't, we said we'd be done in 90 minutes. So, and that is 1 minute away. So I would say that's, oh, hang on. There's one question here from Lucy. Are tenants in common only relevant for married stroke spouses, or can it be for others who might live in a house which might be at risk?
Absolutely, yes. So tenants in common can be anybody, any people who own a house together. So you could have 3 people, 4 people owning a house, and they would own it as tenants in common, each with a distinct percentage share. It's 50-50 in my little diagram, but it wouldn't need to be. It could be 10%, 90%, or 30-30-10, whatever. And always very, very sensible ways then of being able to protect it. But just that important thing to remember, that being tenants in common isn't enough, because if you just take your half share and leave it to somebody by will, then if that was the survivor of a joint asset, you've left it in exactly the same way, unprotected. So it's that key of having that trust in the will to which you leave that distinct share.
And just to follow up on that point, of course, if those people aren't married, then you might end up paying inheritance tax on staying in your own property. So for example, I had not actually a client of the business, but a friend that sadly was in that situation, and she ended up having to pay inheritance tax to stay in the house that she'd lived in many years, just because she wasn't married to her partner.
Yeah, it's a really, really good question. It's one of the biggest problems actually, where a couple are unmarried, then rather than the life interest trust, which is what we were looking at in the slides, a discretionary trust is much more effective, and because then it's not added to the estate of the partner. Otherwise, the revenue, the life interest trust works very well from a tax point of view from the residence nil rate band, as you were talking about, Charlie, because the revenue treat the survivor as if they own the entire property. Works very well for a married couple, doesn't work well for an unmarried couple, because the survivor then has no spouse exemption and therefore would be taxed. So if you use a discretionary trust instead, so still tenants in common, but this time to a discretionary trust, then the revenue then don't treat it as belonging to the surviving partner.
Fantastic. And there's one last question, which is a more practical question, which is, can I have a link for the recording of the webinar, because I had to duck out for a few minutes. We'll send you all the recording, so if you want to watch any of it again or all of it again, you can also forward it on to other people that might find it interesting. So if there's no more questions, I'd like to say thank you all for dialing in, and we will be in touch with regards to sort of following up with the recording. And obviously, if you want to contact us, then the best place to go to is Buckle's website or Official Portfolio's website, and we'll be more than happy to take any questions personally or as part of the business. Thank you very much, and please get in contact if we can be of help.
Oh, thank you very much to everyone.